Or here's an option. Okay, here's an idea. Good night. I think I might have a good idea, Chuck. Or
no license.
No, we could just be constitutional carry like the other 29 states or whatever that are constitutional carry or permitless carry. Like, what a concept. We could just, as a state, we could just abide by the Second Amendment that says the right of the people to keep and bear arms shall not be infringed.
Yeah, but the Supreme Court said you can require a license, and so California is wrapping that one around their shoulders and saying, "Hey."
Chuck, thank you very much for joining me. We have a long list of stuff to talk about, so let's get right to it. Can you tell me what's going on? Let's do a little national stuff, and then we'll do a little California stuff, kind of spread it around a little bit. We've got the assault weapons and mag ban things that seem to be happening everywhere, and there are some key cases. I know we've got one here in California. We've got one in, where is it? Is it Illinois?
Yes, Illinois.
There's the other ones. Can you tell us what's going on with those? Those are a big deal as far as everybody I know is concerned.
That is a case that is quite likely to wind up at the United States Supreme Court. Illinois passed a law that bans basically all semi-automatics. ARs get the headlines, but it's all semi-automatics. All magazines that can hold over 10 rounds, and significantly, parts. So like all the little pins and parts that go in, and not just the upper or the lower, which is a firearm, but the upper part, and all the parts that go into the upper are banned. So you can't repair one. If you had one and it was grandfathered in and you registered it, you can't fix it. So 4 different lawsuits were filed challenging that Illinois state law. They were consolidated, and one has become the lead case. That's the Barnett case, which is represented by Clement and Murphy. I represent FFL Illinois, Gun Saves Life, and a couple other Illinois local folks. And we raised some unique arguments about that right to repair and get the parts to repair guns that are allowed to be kept. Anyway, all those cases, we won on an injunction in the trial court initially in front of Judge McGlynn in Southern Illinois, which is a very different country from Northern Illinois, around Chicago. It went up on appeal. Judge Easterbrook really bent over backwards to hammer us. And but interestingly enough, he left a window open. He said, semi-autos are not arms. They're too similar to fully auto, which aren't arms. Now, both of those statements are wrong. Full autos are still arms. They're bearable arms. Whether or not they can be regulated based on some kind of a historical tradition of banning something akin to a full auto is a separate question. But what the game the courts are playing, and this applies every state in the country, every anti-gun state in the country, is they don't want to say that they say suppressors aren't arms, magazine aren't arms, semi-autos aren't arms. So you never even get to the second step in the Bruin test, which is whether or not there's a historical analog, something from the founding era, which would indicate that our founding fathers would tolerate the modern day law based on what they believed the Second Amendment stood for. If they can avoid that, they want to. So by saying that a bunch of parts or hardware is not an arm, then they don't even get to that second step. So that's what Judge Easterbrook did first time around. He said these firearms are not even arms. That's covered by the Second Amendment. Well, that's baloney. But anyway, it was remanded to have the trial court do further factual development about whether or not an AR is the same as an M16, basically. So we had a 4-day trial, and we were very much involved there every day, as were the lawyers for the other cases. And after a 4-day trial and voluminous evidence, declarations, expert testimony, scientific journals, studies, we packed that record, and the judge again issued this time 160-page ruling and judgment saying, after trial, it's a judgment rather than a preliminary injunction, which is an early on remedy, said the ARs are very much not the same as full auto. Semi-auto and fully auto are two different things. And so that the state lost, and it went up on appeal again. And that's where we were last Monday. I was in Chicago at the Court of Appeal with the lawyers for the other 4 cases, arguing in front of Judge Easterbrook again. But here's the trick. So it's a 3-judge panel. We had Judge Brennan, who was on our side and dissented last time when we lost. And we used to have a Judge Wood, who retired and has now been replaced with Judge St. Eve, who's a Trump appointee. So if we can convince her, we can win 2-1. And we went into that thinking there's no way she's going to come on our side because she had given us some bad rulings in a couple cases before. So we didn't think we had her. We were expecting to lose, but she really showed a lot of knowledge, that she had looked into the issues, that she had studied things. And frankly, I think that she really paid closer attention because Harmeet Dillon, who is the head of the Civil Rights Division in the United States Department of Justice, was there in court. They filed an amicus brief, and she actually appeared and took 5 minutes of oral argument. So appellate courts see things differently when there's a representative of the United States government jumping into your case and arguing.
I was just going to ask you about that. How much help does that actually provide us to have the U.S. DOJ fighting for Second Amendment rights and the restoration of them rather than against?
It raises the profile. She didn't really make any new arguments, but it raises the profile of the case, and the courts take it a lot more seriously. And a Trump appointee, the new judge, is going to take it a lot more seriously and look at things a lot more closely because she recognizes that the whole United States government is saying that their previous opinion was wrong. So, I mean, it also raises the profile if there's going to be a Supreme Court petition someplace in there to ask the Supreme Court to hear it. So I think it helps a lot. That's the bottom line. And the United States Department of Justice is getting involved in a lot of things. They just filed something in Washington, D.C. that said that a magazine is an arm and the magazine bans are unconstitutional. They are abandoning a criminal prosecution of a guy who was prosecuted for possessing a firearm when he used marijuana. So they are very much active in protecting and asserting. And they're getting involved. They got involved in the LA County Sheriff CCW delay case. They're doing an investigation in LA County Sheriff themselves. They've said they're going to look at every California jurisdiction and see if they're slow rolling or charging too much for a CCW. So it's very, very encouraging, and it really changes the game in our favor.
Now, if this goes, I mean, if we have a win with the assault weapons thing in Illinois, does that have any effect on poor Californians who seem to be left out in the cold constantly on all of this stuff?
Well, there are a couple of assault weapon cases that are frozen in court in the Ninth Circuit. There's 2. CRPA has Rupp and SAF-FPC has Miller. So if you get an opinion from the Seventh Circuit, the Ninth Circuit has to take that seriously and look at it very carefully. Unfortunately, in several of these jurisdictions, we've got rulings upholding semi-auto bans. But if you get a split amongst the circuits, that's something the Supreme Court's going to take to resolve the split of opinion amongst 2 different circuits. But a Seventh Circuit ruling, California is not in the Seventh Circuit. California is in the Ninth Circuit. So a Seventh Circuit ruling is not binding on the Ninth Circuit. The only court that can bind all the circuits with its rulings is the Supreme Court. Otherwise, you've got 11 different circuits that could conceivably have 11 different opinions. And they're only applicable in the states that are in that circuit.
Come to me, come to me, come to me. Where's the guy? Come on, step out, step out, step out.
All right, don't say hello. Don't let me do it.
Both of you, step out. I couldn't really make out what went into that room.
Looked like you had a red Nerf gun.
Yeah, like there was something weird there. But I had no shot, so that guy...
Right. Committing to the situation, unfortunately, is what you have to do there. Now, it doesn't mean you have to stand in the fatal funnel, of course, right?
No, I would definitely move. I would be moving to my right as I engaged.
But you put a bunch of well-placed shots, and that whole thing went down in 30 seconds.
So let me ask you to prognosticate a little bit, which I know you hate every time I ask you to do that, but I'm going to do it anyway. The Supreme Court is notorious for being completely unpredictable. I mean, sometimes you can say, well, yeah, I think they're going to do this, or we think they're going to do that. And even after oral argument, we can feel like they're going a certain direction, and then they'll surprise the tar out of you. That said, if we get an assault weapons case to the Supreme Court, what do you think the chances of a victory
We're going to
are?
win it. We're going to win it.
Why do you say that?
Well, you've already know we got at least three judges who wanted to take the Snopes case. And remember, it takes 4 judges to take it, 5 judges to win it. Even Judge Kavanaugh, who did not vote to take the case, said we're going to have to take an AR case soon. And he had already ruled in the D.C., right after Heller, in the D.C. case, that assault weapons couldn't be banned. They were in common use, and you couldn't outright ban them like that. So-called assault weapons, basically the AR. Everybody calls it the ARs. It's about so much more than just the AR. But so we know we have 4 votes to take the case, and at that point, but they just didn't take it yet. And I think the reason is, in fact, Judge Kavanaugh said we're going to have to take an AR case this session or next. But I think the reason they're not taking it is because they're flooded with Trump cases. Like California alone has 41 cases suing Donald Trump over his executive orders and his policies. So they're kind of tied up on their shadow docket, which is the emergency appeals docket. It's not the full briefed and orally argued cases calendar. It's a sort of they call it the shadow docket. It's sort of the emergency docket, like a death penalty. Guys are about to get executed. Supreme Court gets an emergency appeal to stay the execution. It doesn't go through the full process that takes a year. So I think it's just that they're busy, which is why they didn't take the Snopes or the Ocean State Tactical Magazine case last session. But now they've got Duncan in front of them, where it's on a petition for cert. And in fact, that's the magazine ban in California. And in fact, 27 attorneys general just joined us in asking the Supreme Court to take that case. That's another, when states get involved, that helps too. It raises the profile, not quite as much as a United States government getting involved. But when you've got 27 states, a majority of the states saying the court should take a case, that helps a lot. So, but when Kavanaugh comes on board, says, okay, it's time to take a case, all those 4 judges have to do is convince Roberts or Coney Barrett, and Roberts and Coney Barrett have already telegraphed that they're pro 2A. So we're going to win. We'll get 5, if not 6, justices from the Supreme Court, and at a minimum, they know they need to set the Bruin methodology straight. They know that a lot of courts are abusing their Bruin decision, misinterpreting, deliberately distorting the Bruin decision so that they can uphold unconstitutional laws. And they know they have to slap those courts down.
Yeah, and that was what I was going to mention, too, is it seems like every time we get a victory at the Supreme Court, the lower courts either ignore it or twist it. I mean, they bend it and twist it in some weird... Yeah.
They did it after Heller. They did it after Bruin. They're doing it after Rahimi. I mean, they bend over backwards intellectually to twist the Supreme Court's language. And so every time, they misinterpreted Heller, Bruin straightened out a lot of the things that they had misinterpreted Heller, and then they misinterpreted Bruin.
So is there a point at which, like with the First Amendment, that there's such a body of precedent that it makes it harder and harder for them to twist themselves into knots? I mean, is that the direction we're heading?
Absolutely, yes. We are going to get a decision from the United States Supreme Court that not only strikes down a law, whether it's a magazine or a semi-auto or a prohibited places or prohibited people. Sensitive places is another thing we're litigating. They want to designate everything as a second sensitive place, so your CCW is no good. They know they've got to rein these lower courts in, and they've said so. And so have a lot of the dissents in the Ninth Circuit. We have a judge that said the Supreme Court should not be allowing lower courts to flip the judicial middle finger to the Supreme Court. I mean, it's getting very less civil than it usually is in the Ninth Circuit. We have factions of judges that are really butting heads over how Bruin's supposed to be applied and whether a law is constitutional or not.
Is there an opportunity between now and when Trump leaves office for him to make additional changes to the Ninth Circuit? The first time around, he really made some sweeping changes to that court because there were vacancies he could fill. I mean, where do we stand with it now?
There's a couple vacancies, but not as many as there were. He has one candidate up for Senate approval now to the Ninth Circuit, who's very pro 2A. And I think he has a couple more in the works. You know, we need judges on the Ninth Circuit to create a vacancy. They need to go on senior status or fully retire. Judge Akuta has gone on senior status, so that's a vacancy they're filling. I don't remember exactly how many, if there are any other vacancies right now.
Well, some of those judges are old enough that they're fossils. I mean,
and the other thing is Akuta was a conservative, so she's going to be replaced by another conservative. Doesn't really change the math.
Yeah, there you go. Well, we've got some other cases to chat about here. We've got, Duncan, you mentioned briefly.
Duncan is the magazine ban. We have a cert petition in the Supreme Court right now. Hopefully they'll take that.
We've got, I don't know, Miller's the assault weapons thing, so that kind of rolls into the Barnett.
Miller and Rupp are the two semi-auto cases.
Yeah, that's the one you were talking about before. There's Wynn versus Bonta. That was the one gun a month thing, and now they're trying to do.
Struck down. They struck down the one gun a month law as unconstitutional, and that's a final ruling. And that's the first time the Ninth Circuit did not go en banc. They agreed that that was unconstitutional, and the en banc court did not take it. So that's a final ruling. But now the legislature, doing the slimy little tap dances that they do, they proposed a bill that would limit you to 3 guns a month. So we're gonna have to file a lawsuit against that one and use the same language from the first win.
It never ends, man. It just never ends. And that's okay. What the heck? We got the battle.
FBC and SAF win in the one gun a month lawsuit. Hat tip.
Yeah, and then we've got Rhodey, which is the ammo background check thing. But didn't we get a decision on that in July? And where is that now?
We won, and we won, and that was in the Ninth Circuit 3-judge panel. And the state has now asked for an en banc review. We've opposed it. We're waiting for the court to decide whether it's going to take that case en banc or not.
So, I mean, it might not. You know, it's sort of been the default standard is we win at the 3-judge panel and they take it en banc and slap that down. But after the Wynn versus Bonta one gun a month thing, I mean, maybe there's a shot that they don't take it en banc.
Well, I think some of the judges that want to uphold laws, frankly, they're biased. They read things the way they want them to read. They may be getting tired of getting criticized by their colleagues for being not being intellectually faithful to the Bruin decision.
That's a kind way of saying it. Not being intellectually faithful. I would say the bald-faced lying and cheating all over the place. But
you can say that. See, I got to keep my bar card.
I know, but I can say that and you can't. We've covered a whole lot of stuff here. Are there other cases that are? That's kind of a stupid question. There are a lot of cases. Are there other, I would say, earth-shattering or key cases that nationally or in California that we haven't chatted about? We ought to touch on.
We just restarted the challenge to the 11% excise tax case. That is now in motion again. We got a little sidetracked because tax cases are weird. You have to sue the tax agency, not the state DOJ, and you have to pay the tax and then sue to get the tax reimbursed. So you can't have like the same kind of associational standing where you have plaintiffs like CRPA or SAF or GOA, arguing this has to be a taxpayer that then sues. So we had to pull back, satisfy some side requirements. Now we're back in action on that one. That's the Poway case, Poway shooters case. What else?
What's going on with the concealed carry stuff?
Videotape. Oh, that's in play everywhere. We just filed against Santa Clarita. We're finalizing. We're trying to settle with LA County Sheriff. They've promised that they will speed up the process, keep the fees down. Santa Clara's charging $2,000 to get a license that lasts 2 years.
Wait. What? That's what Santa Clara is charging. That does that include the class or the?
Yes, well, not the class, but the psych exam, the live scan, the application fee. All in, it adds up to $2,000.
So here's the problem. Okay, this kind of stuff just makes me mad. I'm not going to get mad.
This is infuriating.
It's infuriating because now you got the average clerk at the average convenience store who arguably needs a permit can't get one because they can't afford to do it. You're pricing out a whole segment of American society of law-abiding and honorable and hardworking citizens who can't afford to exercise their constitutional right.
That's right. This is their passive-aggressive. Well, it's actually not passive. It's aggressive.
I was going to say, what's passive about it?
It's like a side attack since they can't use good cause to just deny everybody anymore. So now they want to make it cost too much, take too long, be too much red tape, so people give up, and then make it as useless as possible because there's so many sensitive places that your CCW is not even valid in a lot of those places. So it's not as useful as it was.
Now
we're getting ready to drop a case that challenges the entire regulatory scheme as taken together, because that's what this scheme allows. It allows jurisdictions to play these kinds of games, say that this is what it costs us. This was classic in some of the other jurisdictions we've sued over the cost. There's no incentive to do it efficiently if they can try and pass their costs along to you. The less efficient they are, the more it costs them, the more they can charge you. And they know if they charge you a lot, you'll drop out. So the whole statutory scheme, the whole state law taken as a whole, I think is unconstitutional because it allows these kinds of gaming the system.
Well, and the Bruin case, I mean, if I remember correctly, the Supreme Court said, yeah, you can issue, you don't have to, basically, I mean, I don't remember the language, but you can issue a permit if you want to, but you don't have to. But if you're going to issue a permit, it needs to be like unto these other 40-some-odd states.
Well, it didn't specifically say like the other states. It said you can't have excessive costs and you can't have undue delays. So that's what California is.
Both of which we have.
Yeah, exactly.
Right. I mean, even the counties that are kind of trying to get them done quicker take forever and a day. I mean, San Diego.
Well, I mean, like
forever.
Riverside, for example, they have, they basically put a couple of active duty deputies in charge of the unit, and then they hire retired deputies to come in and work by the hour, and they'll staff up or staff down depending on how many applications they get so that they can process an application in a matter of weeks. Meanwhile, LA Sheriff and LAPD take 2 years.
And I know it's more of a Rick Travis question at some point, but I mean, in the meantime, the legislature with, AB 1078 is trying to make additional changes to the way that concealed carry licenses are done. I don't know if that's good or bad. I'll get Rick on here. We'll ask him, but it's
I know we tried to get a bill through that would extend the license period from 2 years to 4 years. Now that's a step in the right direction. Now, rather than $2,000 for 2 years and $1,000 a year, it's $500 a year. That's still way too much. Yeah. But the point is, if it's a 4 year, and there's no reason that it has to be 2 years. You could make it indefinite and just have people get a certificate of eligibility so that if they lose their right to own a firearm, the SOE is triggered, they lose their COE, and then they lose their license, their CCW. If you become a prohibited person, they can be informed of that through the certificate of eligibility system. So why have a deadline at all?
Or here's an option. Okay, here's an idea. Good night. I think I might have a good idea, Chuck. Or
no license.
No, we could just be constitutional carry like the other 29 states or whatever that are constitutional carry or permitless carry. Like, what a concept. We could just, as a state, we could just abide by the Second Amendment that says the right of the people to keep and bear arms shall not be infringed.
Yeah, but the Supreme Court said you can require a license, and so California is wrapping that one around their shoulders and saying, "Hey,
we're going to do it whether you want it or not."
Right. Exactly.
All right. Well, there you go. I mean, I guess if I were king for the day, but I'm not.
I know. Wouldn't it be great if we ruled the world?
We'd have so much fun. There'd still
Everybody wants to rule the world.
Some people would love us, and others would be continually pissed.
Huh?
I kind of like that, actually. Anything else we didn't talk about that we should?
I'll throw this out there. CRPA is moving its headquarters. The building we're in and been in for 40 years is falling apart, and we really, really need. We're going to. The landlord won't fix it. The rent, they want to raise our rent. We found a much better building with signage and a bigger training center and a lot of room to do things better and expand our influence and expand our programs. We do need support. So if folks can check out the CRPA website, crpa.org, help us out there. It's going to be, it's a power up, to use a gaming analogy. We're going to become a much better, more effective, more efficient, more influential organization in that new headquarters. So we need help with the move. Rent's going to stay the same or go down, but the move is
still going to cost you to move.
Pricey.
Right?
So
you heard it here first. Okay, maybe not, but you heard it here. CRPA is leveling up. That's a very encouraging thing. Are you standing in Fullerton, or are you moving someplace else?
I think it's one town over, but it's in the same area.
Yeah, cool.
It's right off the freeway, so we have a big sign, a big billboard that we can put up that all the cars going up the 405 freeway will see.
Oh,
so,
I'm liking it. As soon as you get in, I got to come visit.
Absolutely.
Hey, Chuck, thank you very
have
much.
An open house. And let me just last say, so Second Amendment Law Center, we're still very active in amicus briefs all across the country. 2alc.org, numeral 2alc.org. If you guys can help out, my firm does not, they get nonprofit rates. All these groups get nonprofit rates. So don't tell my wife that I'm not charging full boat, but and we make it, we do not play any games for those finances. We have all kinds of committees and auditors and accountants looking over, making sure that money is spent efficiently and there's no side rackets going on as there may have been with some other national gun rights group. And all the stuff I do is pro bono. I'm not just an advocate, I'm an activist. I truly believe in this. If I wanted to just make money, I would have stayed at a big firm and represented oil and gas companies and cigarette companies. So help us out, and we'll secure freedoms for yourselves, for us, and for our next generation. Don't give up hope. I know it's taken too long. I know the wheels of, I don't want to say justice, the wheels of the civil law system take time to turn, but we are getting there, and it will be sooner rather than later we get something positive.
So I'm just going to say it. The wheels of the injustice system move slowly, and that's kind of the problem. But that's okay. We'll still use the system, and guess what? We're still going to win. How about that?
We are. It's just a matter of time. Yes, we'd rather have it sooner than later, but we're going to get it.
Yeah, and we're getting it. We're getting it, and it's going to.
We're winning battles. We're winning battles.
I got to tell you, I'm very encouraged by your response when I ask you about if the Supreme Court takes a semi-auto ban case. I'm not going to call them assault weapons because it's a made-up political term that means absolutely nothing. But if they take the semi-auto ban case, that we're going to win. Because they're going to take one. They just are. I mean, it's a matter of time, and then that knocks that bowling pin down too. So very, very encouraging news, Chuck. Thank you very much for coming on the show. It's been too long. I really do appreciate you.
Thanks for having me, brother. Always a pleasure.
Man. Have a great week.